case briefs, and so much more. LSData's got what you're looking for.
In 2012, the Supreme Court of the United States heard the case of Freeman v. Quicken Loans, Inc., which centered on the interpretation of a provision in the Real Estate Settlement Procedures Act, RESPA. RESPA regulates the real estate settlement services market, including services such as title searches, insurance, property surveys, and document preparation. One of the Act's consumer protection provisions, Section 2607(b), prohibits the giving or accepting of unearned fees for settlement services. The issue at hand was whether this provision applies to a single settlement service provider's collection of undivided unearned fees, or only to transactions where a provider shares a part of the settlement service charge with others. The court analysis focused on the interpretation of the phrase portion, split, or percentage in the provision. The petitioners argued that RESPA prohibits the collection of undivided unearned fees, while the respondent argued that it only covers situations where a settlement service provider splits a fee with one or more other persons. In a written opinion by Justice Scalia, the court held that a violation of Section 2607(b) does not require demonstrating that a charge was divided between two or more persons. Instead, the plaintiff must prove that a charge for settlement services was divided between multiple persons in order to establish a violation of Section 2607(b). Since the petitioners did not claim that the respondent split charges, the court ruled that summary judgment favoring the respondent was appropriate. The decision of the Court of Appeals was ultimately affirmed. This outcome aimed to eliminate kickbacks or referral fees that increase the costs of certain settlement services and to protect consumers.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.